Good evening and welcome. It's my pleasure to welcome you to our Alzheimer's Society of Saskatchewan Evening of Education. Tonight's presentation will be on legal issues for people living with dementia and their care partners, featuring our guest presenter, Ted Koskie. My name is Heather Dash, and I am the Program Manager for the Programs and Services team for the Alzheimer's Society of Saskatchewan. As we gather here today, I acknowledge that I'm joining you from Regina, which is in Treaty 4 territory and the homeland of the Métis. The people of the Alzheimer's Society of Saskatchewan are privileged to live and work across the traditional sacred land, as we now know as Saskatchewan. We recognize the legacy and enduring presence of the Cree, Dakota, Dene, Nakota, Lakota, Sioux, and Métis people, who are the original stewards of the rolling hills, rushing rivers, and living sky we all share today. As an organization, we acknowledge the harms of the past and how Indigenous people are still impacted by the process of colonialism. Through education, partnership, collective action, we commit to honoring our relationship with the land, our treaties, each other as we journey towards reconciliation. Now, before we begin, I would like to take care of a few housekeeping items. First off, I would like to thank our supporting sponsors, SaskTel, TelCare, and SGI. The presentation tonight will be recorded. Please know that only the presenter is being shown on screen. As participants, your faces and names will not be shown, and you will all be muted. If any attendees would like closed captioning, we have enabled automated captions you can select at the bottom of your screen. Following tonight, an email will be sent to you with a short evaluation survey and links to education resources. During the presentation, you can type your questions for the presenter in the Q&A function near the bottom of your screen, not the chat box. We will have a brief question period at the end of the presentation where I will read questions that have been typed in to the presenter. We ask that you keep your questions relevant to the topic being presented tonight, and general questions only, not personal. The presenter will not be giving personal advice and will not comment on personal situations. I would like now to welcome our presenter, Ted Koskie. Now, Ted didn't feel he needed a big introduction, but I wanted to share a bit about his background. So Ted comes to us tonight as a volunteer lawyer with PLEA, which stands for Public Legal Education Association. It is Saskatchewan's source for free legal information. Ted Koskie is also the founder and managing lawyer of Koskie Law with over 40 years of experience. His practice encompasses a wide range of public sector issues, including government, public utilities, and healthcare. And in 2018, Ted received the Cam Partridge Memorial Volunteer of the Year Award from the Public Legal Education Association of Saskatchewan. Ted, I will now stop sharing my screen so you can start your presentation.
All right. Well, good evening, everyone. I think what I will do is I will just begin to share my screen if I can. Let's see how well I can do that. Now, are we sharing? Perhaps you can just let me know, Heather. Oh, I'm sorry, not quite.
Yeah, you're sharing, but we can see your slides on the
How's
side.
that?
There, that's good.
Does that make sense? Okay. Yes, there really is very little need that I have for introduction. I mean, Heather's indicated that I've practiced for more than 40 years. I'm now in my 45th year of practice, and this is something that, at least from my perspective, I consider to be a very important role for volunteers that are lawyers in the province. The Public Legal Education Association does a wonderful job in terms of making people like me available to others to try and share what I guess little knowledge we have on subject matters that are of interest. Heather has indicated that we have a specific topic to deal with tonight, and that's wills, estates, and powers of attorney, and the things that are tied to them. I provided a PowerPoint presentation, which is on the screen now, and I think that a copy has been distributed, and if it's something you haven't been able to see, I think will be available to you. I'm not intending to follow slide for slide through this particular presentation. I'm hoping that what it does do, I think there are like 24 slides. Hopefully it will give some basic information about the topic that we have tonight. Having said that, I welcome you to look at that after the fact. I am, as Heather indicated, I'm happy to take questions at the end of this presentation. As well, I guess if there are questions that I'm either not able to answer, in other words, you are stumping the presenter, I'm happy to take the time to try and look up those answers and then perhaps to provide them to Heather and allow her to circulate them at whatever opportunity she has. With saying that, I think I'll just sort of jump in. I think what becomes important at the outset is to draw a distinction between wills and powers of attorney. And I use powers of attorney, or the expression powers of attorney, in a very broad context. And so when you hear me speaking of powers of attorney, you're going to find me lumping in healthcare directives within that. I do that for a specific reason. Wills are what we call a testamentary document. All testamentary means is that it speaks from death, meaning whatever happens to be within your will really has absolutely no effect until we die. On the other hand, powers of attorney and healthcare directives are what we call living wills, or the nice Latin expression is inter vivos documents, which means they speak while we are alive. As the will only speaks from death, the power of attorney and the healthcare directive only speaks while we are alive. The moment we die, the will takes over. And so it becomes important to keep that in mind, because if we look at generally what a will really does two things. The first thing, and it's the thing we all think about, is that it lets us distribute or dispose of our property, our stuff. And in practical terms, I mean, that's what we think about all the time is, okay, if I have a home or if I have other property, who is going to get that? It does one other thing, and is commonly done, is that we often will appoint guardians in the event of our death. Now, the reason why I sort of keep harping about the distinction between when a will is effective and when a power of attorney or healthcare directive is effective is that a lot of times people think that if they've made a guardianship appointment within their will, that if something happened to them, but they did not die, in other words, they were at a point where they were unable to make decisions or unable to care for those over whom they have guardianship. A lot of times people think, oh, well, I made that appointment within my will, so I'm taken care of. Unfortunately, that's not the case. Because again, as I said, the will only operates if you're dead. So if you're lying in a coma in a hospital after a car accident, unfortunately, the will is not operative. It's why when we look at what an inter vivos or our living will does, it really does a variety of things. The first thing it does is it lets us appoint an attorney. Now, when we say power of attorney and we appoint an attorney, we often get ourselves confused with the American expression attorney, which is synonymous with lawyer. In Canada, we are not called attorneys. We are called lawyers, I guess, but in sort of the English tradition, we are what are called barristers and solicitors. In fact, in England, they function in two separate ways. You either have barristers or you have solicitors. In Canada, we are both. But don't confuse the expression attorney and a power of attorney as being a lawyer. It does not have to be a lawyer, and in fact, in most cases, it is not. But what we do in a power of attorney is we appoint that attorney to do certain things. The attorney can really do two things. The attorney can manage our financial affairs. In other words, they can pay our bills, or they can sell property, they can mortgage property, they could do a variety of things. And I'll get to the specifics of a power of attorney in a bit, but nevertheless, that's one of the major things that an inter vivos document does. Another significant thing that a power of attorney does is it allows attorney to make decisions about personal matters. And we shouldn't necessarily confuse personal matters with healthcare decisions. They are different, even though there may be sort of this perception of an overlap, and in some respects, there probably is an overlap. But the idea behind personal decisions would be what kind of care. They might be particularly if it, were related to, perhaps a special care home that one might reside in, and decisions that might be made in terms of care that would take place there. It's those kind of decisions. The third component of these inter vivos documents is a healthcare directive. That is what has most commonly been called a living will. But from a legal perspective, a living will really is anything that is operating while you're alive. So hence, a power of attorney is also a living will. It just so happens that we have different laws or different pieces of legislation that set out sort of the rules with respect to powers of attorney and with respect to healthcare directives. They're different, but they both really constitute a living will. When I draft, for example, a living will, I don't draft two separate documents. I don't draft a power of attorney and then a separate healthcare directive. I do them in one document. Why do I do it? It's really just a matter of personal preference, just so that there aren't multiple documents floating around. So ultimately, that third component of being a healthcare directive is where we appoint an individual. That individual gets a bit of a different name. We don't call that person the attorney. We call that person a proxy. And the proxy is able to make healthcare decisions for us. And again, we'll be able to make healthcare decisions based upon what you have specified. And I'll deal with that in more detail as we go along. But that's the fourth component of this living will. Or I should say the third component. There is another component, and that is guardianship. So I spoke to you about guardianship within a will. Well, you can also make a guardianship appointment within your living will. And you want to do that because, pardon me, if that need arises while you're still alive, you cannot rely on an appointment within your will. So ultimately, if you have it within both your living will and your testamentary will, in other words, your last will and testament, and I'm going to now generically talk about, rather than using inter vivos, well, I'll just call it power of attorney, but appreciate it includes healthcare directives, at least for purposes of my chat tonight. It's important to have it in both so that you are covering both bases. Now, I don't have a clue of the demographics of who I'm speaking to. And I have no idea whether or not, I mean, when I speak of guardianship, that it generally becomes more so an issue when one has children that are under the age of majority. But I always harp about it, even with people that are older than that. Like, for example, I have grandchildren, so I don't have any children that are under the age of majority. But I always harp about this in the hope that what people will do is make sure that if they are ever discussing these things with their children, that they're making sure that appropriate provisions have been made for guardianship of their grandchildren. So it's important to know that those really are sort of two broad categories of documents that we're going to talk about. In some respects, some of the principles that apply to one will apply to the other. And you'll see there are some similarities as we go along. Now, there are a few things that I'm going to sort of try to get out of the way at the outset. And that's just sort of a few little technicalities, I guess. And, you know, I'm hopping to sort of this next page, and you'll sort of, there are these sort of word definitions. And I want to try to get rid of the mystique of some of these things. When we draft a will and we appoint somebody to manage our affairs upon our death, we, as the person who is drafting that will, is called a testator, or at least we are called a testator if you are male. So it's just the masculine of the person who is making the will. If you are female, then it is testatrix. And these are just things that are drawn from Latin derivations, nothing more, nothing less. If we were talking about the plural, if it was two males, we'd be saying testators. If it were two females or more, we would be saying testatrices. And so when you hear these kind of expressions, they all mean the same. They are just sort of giving a gender to it. Same thing happens in terms of when you see executor or executrix. Much like I just said, the person we appoint to manage our affairs is an executor if that person is male, executrix if that person is female. Again, if we go to plural, executrices, executors, that sort of thing. Understand that when you hear the expression executor, it means it is a will-appointed person. So we might say, okay, well, the heck are you talking about? Well, you'll see a few lines down, there's this expression called administrator. Whenever you hear the word administrator, it means the person is appointed by the court to administer the will. Now, you might say, well, when does the court do that? Well, if I'm appointed to be the executor and I've died and there is nobody appointed as an alternative executor, well, then one needs to have the court appoint somebody to replace me. So you might still have a will, in which case you would be called an administrator with will annexed. And we'll come back to that in a minute. But again, we get, to the point where if a person died without a will, in other words, we say that person dies intestate, meaning having no will. And ultimately then, again, we need to have the court appoint somebody, and they would then, the person who's appointed to take care of the affairs is called an administrator. So whenever you hear the word administrator, you know that it's a court-appointed person, either with a will or with no will. And so I mentioned somebody dying without a will. The word underneath administrator is intestate, and that really is all it means, is that the person died without a will. What is it if you died with a will? You are testate. And that's really when, if we go right up to the very top, we see testator. It's really how these things all intertwine. Now, you'll see that there is a word that's sort of second from the bottom, and it's called probate. And lots of people sort of hear the word probate, don't have a clue what probate is, and don't know whether they need it, don't need it, or what it is. In law, in a very strict sense, a will is all the authority that an executor or an administrator needs to handle the affairs of the deceased. Our problem is that in sort of this day and age, and in fact, it has been for a long time, there are some entities that we deal with that are scared to deal with the executor or administrator. And when I say scared, they're worried that if Heather walks into a bank with Ted Koskie's will and says, hey, I have been appointed the executor, give me all the money that's in his bank account. The bank is worried of what happens If Judy comes in a month later and says, I've got Ted Koskie's will and I want the money in his account. And they say, well, sorry, we just gave it all to Heather. Well, they're afraid of getting sued if ultimately the will that Judy carries is of a later date than the one that Heather had. So how do these institutions sort of protect themselves? Well, the way they protect themselves is they say, we're going to force you to get a court order that says this document is the last will and testament of Ted, and Heather is the executor. Then the bank is dealing with Heather on the strength of a court order, and then the bank doesn't worry about getting sued. And so in a way, it is nothing more than that institution forcing you to go to a court to, in a sense, give them a security blanket. Now, whether we like it or not, it happens. It happens in a couple of instances, just as an absolute matter of fact. If a person dies with land in their name, not in joint names, and we'll get to that in a moment as well, if you die with land, our land title system, it's the Information Services Corporation, ISC, forces probate. They just simply say, we will not transfer that land without having letters probate. The other instances where we see simply no sort of flexibility is when somebody has investments or savings of any kind of substance. And when I say any kind of substance, I say, literally, if somebody has 20 grand or more, you're likely to have a financial institution force you to get letters probate. So they are a fact of life, and they are something that we just simply have to deal with. But appreciate that's all it is it is just a court order establishing that the last will and testament is what is attached to their order. Now, you see in the very bottom, there's this thing called letters probate and then /admin. Well, the court order isn't called a court order when they say that. It's called letters probate. So that's just a fancy way of saying court order when it relates to a will. Now, you'll see admin is after it. Letters of administration only apply to saying, oh, well, this is the same thing as probate, only it's relating to appointing an administrator. So in other words, letters of administration apply when there's no will. In other words, we're dealing with an intestacy, or we're dealing with a will, but there is no executor appointed within the will, so the court is then appointing an administrator. So letters probate or letters of administration are just fancy expressions for court order, all having the same impact as probate. There's one little word that I didn't sort of talk about, and that's codicil. Most people have never even heard of codicil or don't really get concerned about it. And codicils are, I think, becoming a bit of a thing of the past because of computers. But codicil is nothing more than, again, a fancy word for amendment. So if somebody didn't want to, in a sense, completely rewrite their will, but wanted to make some change that was modest or minor, they could simply do a codicil that says, hey, I'm not changing my whole will, I'm just changing paragraph 2 to say the following. Codicils were far more common back in the day when we didn't have computers and we had to completely type things, and we didn't want to have to go to the trouble of having to retype something without spelling errors and all the rest of that. And so it was easier to just do a little 1-paragraph codicil than having to maybe retype a 10-page will. Nowadays, with computers, it's very easy to just pull that document up, make the change, and just reprint the will. I can honestly say I can probably count on one hand the number of times I've written a codicil in the last decade. So it's not very common anymore, but nevertheless, if you ever hear that expression, it's an amendment. It's not the same as the whole will. So now, Again, and you're going to find I'm going to sort of jump over these things because I've already said, look, this is what a will actually does. It can appoint guardians and all of that good stuff. And so you'll be able to sort of see uh, who does that. Now, I mean, this might sound like sort of an obvious thing, like why have a will? Well, the key thing really is the very first line that I have there is it lets you decide how things get dealt with. Now you might say, well, that doesn't make any sense. I mean, it seems like an amazing grasp of the obvious. But what we need to keep in mind, and I'll get to this a little bit later, but if a person dies intestate, well, we don't have any directions as to what has to happen. And so ultimately, if somebody dies intestate, we get ourselves to a stage where there is another piece of legislation, and it is called the Intestate Succession Act. And what the Intestate Succession Act does is it says, oh, well, if you don't have a will, we're going to tell you what happens with your will. And I might as well go through that with you now, but what it basically says, if you got a spouse gets the first $100,000, and then it gets divided amongst children. If you have one child, the child gets half of what's above the 100,000. If you have greater than one, then it's shared. So ultimately, what you see is you might say, well, okay, that might seem logical as well. But in a lot of instances, people will say, well, no, if I die and my spouse is still alive, I want my spouse to get it all. And I'll leave it up to my spouse to sort of decide, how to dispose of things upon his or her death. And in fact, most times people don't even say, I'm going to leave it to my spouse. What happens almost invariably is that when I'm drafting wills, I have spouses that come in and they are really doing something which I call reciprocal wills. In other words, they're sitting back saying, okay, we're going to determine what is to happen, or in other words, to be the common direction that would be given on the death of the survivor. So that ultimately what you really have is a will that in first instance says all to spouse, alternatively, and then that is what is in a sense the same in each party's will. And sometimes, that can be significantly different than what you would see under the Intestate Succession Act. And you'll see the third line that I have here is trusts. And one might say, okay, trust, we hear these expressions. Really, the will is, in its entirety, a trust document. What does that mean? What it means is that when you appoint an executor, the executor is charged with acting in the best interests of the beneficiaries. Who are the beneficiaries? Well, those are the people you've left things to in your will. Well, when you say they have to act in the best interests, that means they have what's called a fiduciary duty. You hear that expression a lot. In fact, sometimes you see it on commercials. We have a fiduciary duty. Well, what it means is you have a duty of trust. And that means act in the best interests of the beneficiaries. One might say, well, that's an obvious sort of thing. But sometimes the line gets pretty murky. We see odd sort of things where somebody says, gee, I think I need to have my house renovated so I can take care of, certain matters or whatever. Well, that wouldn't be acting in the best interest of the beneficiary. And I tried to use something silly, but nevertheless, you have to be very cautious that you are always acting only with the beneficiaries in mind. Sometimes, though, and I am finding that this is becoming more and more a frequent occasion. In the early days of my practice, I rarely saw this, but we are now encountering on a variety of occasions individuals that have various illnesses. Sometimes that might be a drug dependency, it might be an alcohol dependency, it might be a gambling addiction. It could be any number of things that cause, and I'll speak of it as though it's a parent referencing a child because it's easier to use that as the example. where I have a parent coming in saying, my son is a drug addict. I cannot leave the estate to him because he'll just blow it. And so often what is happening then is they are creating a trust. In other words, a mechanism where funds can be set aside and managed for the benefit of that person. So sometimes that might be creating an annuity that might sort of pay something out over a period of time. Other times it may be something as simple as saying, trustee or executor, you hold it and draw upon it as you think in your discretion is needed for that person. But it can be anything that you direct. You could appoint a trust company to manage it. You could appoint an accountant to manage it, sort of anything that you choose to do. But I am finding that particularly with individuals that have drug addictions or gambling addictions, that is something that is becoming very, very common. I could say that when I would maybe, I'm going to call it the old days, decades ago, I'd maybe encounter that maybe once or twice a year. It's now not uncommon for me to encounter it, once or twice a month. So it is becoming something which, in a distressing manner, is becoming more and more a problem. Now, we talk about who gets to make a will or who can make a will. Again, what I've set up here might seem obvious, but actually I do it for a purpose. People often get confused because the legal drinking age in Saskatchewan is 19. But that's not the legal age of majority. The legal age of majority is 18. So in order to be able to do a will, you have to be 18 or over. It's not 19 or over, it's 18 or over. There are a couple of exceptions, and that is if you're under 18, but you're married or you're in the active armed forces, you are allowed to make a will. And I guess those sort of seem like sensible sort of exclusions, and those kind of exclusions have been in place for a long, long while. Now, we talk about legal requirements. And again, often I find people saying, boy, I'm worried somebody's going to contest the will. And they don't really know, okay, on what basis can somebody contest? Well, the only basis really that one can contest a will is if an individual lacks the capacity to make that will. So what do I mean by that? A lot of times we might say, oh, that person has to be completely certified to be, mentally incompetent. And that's not so. The test that the courts use is really twofold, and it really is in the 2 bullet points that you'll see in this page. People need to be able to understand what they have. In other words, the value and extent of their property. People might say, well, that seems obvious, but you'd be amazed by the number of times that people really don't appreciate what they have. They don't understand sometimes the value of what they have. That's particularly happened with farmland as of late, which has increased significantly in terms of value. But people may not know what shares are worth. They may not even know they have shares. They may not know they've got certain properties or a right to certain properties. So really, the idea is that you really have to know or have at least a good sense of what you've got. That doesn't mean you have to know it to the penny. Most people haven't a clue to the penny, what they have, and that's not the rule. But you have to have a good sense of what you got. And that really is a two-way street. People might sit back and say, oh, well, you have to know you got something. Well, you can't sort of think you got something but not have something as well. So it really is a two-way street. You need to sort of have a sense of what you have. Then what you need to do is you have to have a sense of who might be your potential beneficiaries. It doesn't mean you have to leave something to your potential beneficiaries, but you have to have some sense of who might be people who potentially could benefit from, your bounty. That's the snazzy expression courts use, is who might benefit from your bounty. That might sound a bit odd, but you often see on American television where somebody says, "Oh, I leave my brother Joe $1," when the guy's a millionaire. And you say, okay, why did he do that? Well, what he was trying to do was he was trying to say, boy, when I've left him $1, that's telling the world at large, I knew he was a potential beneficiary, but I'm really quite purposefully ruling him out. And so that's how that sort of idea of sort of leaving somebody $1 sort of came about. It's very much an American practice, not a Canadian practice. I often have people coming into my office saying, okay, I'm worried somebody will challenge and, I'm going, I want to leave $1 to, sort of everybody under the sun that could potentially have been a beneficiary. It's really not necessary. Because what we need to appreciate is that if somebody is attacking a will, it is the attacker that has to establish that the testator didn't understand what they had and didn't know who could potentially be their beneficiaries. And that's not necessarily an easy thing to do. And so we get ourselves very much to a stage where sometimes, in fact, you're better off not trying to think of everybody you could possibly leave $1 to, because then almost invariably you're going to leave somebody out. And it becomes a bit silly after a while. I think that what becomes important is that we realize that it's just these two factors that really are considered when we talk about capacity. There's that third bullet, and I'm going to get to that in a second. But ultimately, and I'll use an example. I once represented an estate where an individual, absolutely incredibly eccentric. People thought he was a very, very odd duck. And anybody that met this fellow would have sworn he was a homeless person. When he died, lo and behold, the guy was worth millions. He left his entire, he had 3 sisters. He had no spouse, no children. He had 3 sisters. He left his entire estate to 1 sister. Needless to say, the other 2 sisters were annoyed. They tried to challenge the will, saying, this guy clearly didn't have capacity. Look at how odd he was. He was a millionaire and he lived like a pauper and all of these sorts of things. It had to show that he didn't really have capacity. In that instance, the court said, no. I mean, this guy can be odd. He can have quirks. He can have idiosyncrasies. But you got to prove he didn't really know what he had, and he didn't really know who his potential beneficiaries were. And it became pretty clear, in terms of looking at this fellow's circumstances, that the reason he left everything to the 1 sister was she was the only one that had the time of day for him. The other 2 never saw him, never phoned him, hadn't seen him for decades. The other one would come and visit him, would call him, would keep in touch. It made perfect sense. But this fellow was saying, hey, I'm going to leave it to the person who he had a relationship with. And so you get to a stage where, being odd or having idiosyncrasies or that sort of thing doesn't mean you lack capacity. It may mean you're odd, but if you understand what you've got and you understand who could be your potential beneficiaries, capacity is not lacking. Now, there's one other thing that affects capacity, and it's of a bit of a different flair than sort of understanding, but it's this concept of force, threat, undue influence. We say that a will, in order to be made, must be made sort of a free mind. It must be something we're doing of our own free will. If we're doing it because we're being threatened, if we're doing it because we're frightened, then ultimately, if we can establish that, a court will say, no, a will must be free from those things, and if it is not, then it is not valid. And you would be absolutely amazed the number of times that, well, I'm amazed the number of times I encounter somebody who is threatened. And it's amazing, that this is usually a son or a daughter coming in and threatening, Mom, I'm going to kick you out of your home if you don't leave everything to me and cut out the rest of the folks. And that sort of thing happens an awful lot more than what we might think happens. So often forces or threats or undue influence happens. Often happens in instances where people are under the care of a specific individual. Sometimes that caregiver sort of thinks they're entitled, that, gee, they're the one caring, and ultimately they're the ones that should at least benefit the greatest from an estate, when that really isn't the case. A person is quite entitled to do what they wish with their will. And so ultimately we are at a stage where that's the thing that becomes very important. On a previous slide, I think I said, you can do whatever you want. I guess it's a little bit later, but the whole point here is that when you are making your will, people will often sort of ask me, well, do I have to do what's fair? And I say to people, no, you don't have to do what's fair. In fact, fair has nothing to do with a will. In fact, a will can be completely unfair if you wish it to be. As long as you understand what you've got and understand who your potential beneficiaries are, you can be wildly unfair. Nice or fair doesn't have anything to do with it. You are entitled to do what you wish. Sometimes people look and sort of interpret unfair as being, well, it has to be equal or else it is unfair. So I'll give an example. I had a lady who I did a will for. She was a very wealthy lady, and she had 2 sons. And she came in and she left her entire estate to one son and not the other. Now, when speaking to her, I was trying to get some sense, okay, trying to figure out, is she being influenced? Is there something there that's causing her to leave to one and not the other? And what I discovered was, one son was a doctor who was a specialist in the States and was a multimillionaire. The other son was hard pressed and had very little and really sort of needed the funds. And so what she was doing is she was helping the one that needed it and leaving out the one that didn't need it. Logical? Sure. Was it equal? No. Is that unfair? Well, no. Fair is a matter of perspective. And maybe even the wealthy son might have thought it was unfair, but it's none of his business. It's up to the testator to decide, and you can do that. And so this concept of equal has nothing to do with it, nor does fair have anything to do with it. A person is quite entitled to decide what they think makes sense. Lots of people sit back and say, look, I've given my children enough during my lifetime, I'm going to leave everything to charity. Well, the children might say, hey, that's unfair, but too bad. That's ultimately what an individual is entitled to do. Now, there's certain times you're not entitled to do that. And you're going to find way down in the slide, there are a couple of things that are exceptions. If you have dependents, the law, and it's called the Dependents Relief Act, will say you must make provision for your dependents. In other words, you can't sort of leave these dependents destitute. And ultimately, if there is some challenge to whether or not adequate provision has been made, then an application can be made to the court for the court to determine what is appropriate. Sometimes that could be the entire estate, or it can be a portion of it. People might think dependent is only child. It is not. We can have dependent adults. And so that can also be the case. The time period is 6 months. In other words, there's a 6-month period of time within which an application can be made to have the court determine that adequate provision has been made. The second, which is, I think, often something people don't really think about, and that is the rules that come under what we call the Family Property Act. Sometimes people try to give away what they don't have. And that might sound a bit odd, like who the heck can give away what they don't have? Well, this isn't quite as common in this day and age as it used to be, but it's still the case. There are lots of times when spouses may live on property, but the property is only in one person's name. It was probably more common sort of back in the old days where father would pass along land to son and, they'd get married and property would never get changed into joint names. Well, a lot of times when people have property that's in one name, they sort of say, hey, that's mine, so I can give it away. Well, not always so, because under the Family Property Act, there is a right for a spouse to seek division of family property, regardless of whose name the property happens to be in. And so even though somebody might think, say, the family home, because it's in their name alone, is something they can give away, the Family Property Act presumes that that property is jointly owned unless otherwise. And so again, there is a 6-month period of time within which a spouse can go to a court and say, just a minute, this person's trying to give away my share of the property, and to have the court deal with it and sort of make sure that that isn't something that is going to be given away, at least to the detriment of the person. So we get ourselves to a stage where when I say that you can do whatever you want, there are some restrictions that come into place. Now, sometimes things will depend on where you have your property. And this is something that I'm finding comes into play more and more frequently now because travel is becoming so much easier. There was a time when people rarely left their communities. Now people leave countries, leave continents. And so it's not uncommon for property to exist in another country. And so ultimately, when that occurs, one will need sort of to take this will and actually have the will acted upon in that country. We have again, a nice little expression for it. It's called resealing the letters probate or letters of administration. And we do that in the jurisdiction. And then ultimately that, it gets dealt with in that jurisdiction. So we can't, in a sense, for example, deal with land in England that, from Canada. It needs to be dealt with there. How am I doing for time, Heather?
You have probably a little less than a half an hour before we get to question period. So
Okay.
maybe jump ahead to
Okay. Yeah, I'll do my best to sort of do a bit of a fast forward because we really haven't talked about powers of attorney and we haven't talked about healthcare directives. So look, and pardon me, I mean, I could spend weeks talking to people about these topics, but nevertheless, you're going to see that maybe some of this stuff you'll be able to just pick up from the slides, but appreciate when you do a will, normally a will, if it is not entirely in your handwriting and not dated and shown to be a will, in that case, if it is entirely in your handwriting, and we call it a holograph will, and that is a perfectly valid will. If it is not entirely in handwriting, it must be witnessed by 2 people, and those 2 people cannot be a beneficiary or the spouse of a beneficiary. So one has to remember that. You can't sort of, you got to be careful with it because ultimately we could be at a stage where that will may not be found to be valid. In terms of canceling a will, most wills start by saying, hey, I revoke my previous will. But if you don't have something that's doing that, if it's destroyed, it's not just accidentally tearing it up, but you have to actually destroy it with intention or direct somebody to destroy it. And those are really the only ways that you get to cancel a will. But there's one way that a provision in a will changes, and that's if you get divorced. If there is a provision in a will to a spouse, then that provision ceases. It's treated as though the spouse had predeceased. If you were living common law, then it ceases if you've left something to that common law spouse, after you've lived for a 2-year period of time, separate and apart, then that provision will cease to apply, but the rest of the will stay in place. Something to keep in mind, and we appoint executors or we appoint guardians. Remember, people don't have to accept it. And so it really is very important that you speak to people and ensure that they are agreeable to serving. And I often say to people, it just makes no sense to go to somebody that has 10 children and say, hey, will you agree to be the guardian of my 10 kids? You just know they're not going to have the capacity to do that. Or to go to somebody that is 90 years old and say, hey, are you going to take care of my kids? So people have to sort of think about what's practical and ensure that, there are instances where people either may not have the ability to do it or may refuse to do it, in which case then people are making applications to courts to have those kind of things dealt with there and appointments made. So you want to avoid that, and really the sensible way to avoid that is to get to a stage where ultimately you are having what you want to have done properly take place. Now, a power of attorney. I've spoken to you about a power of attorney a little bit before and said there are sort of the 3 things that you can do. And you'll see that I've listed them on this slide that is sitting on the screen in front of you. Now, the thing to keep in mind is the idea of a power of attorney is that it's sort of allowing somebody to make decisions for you. And it used to be, back in the old day, powers of attorney weren't even available for individuals. A power of attorney was what we call a common law sort of right for businesses. Corporations gave a power of attorney when ultimately what you were doing is empowering somebody to sign documents on behalf of a corporation. And that's really how powers of attorney came about. Well, individuals wanted to sort of be able to have somebody make decisions for them, and ultimately it required legislation to actually make this sort of thing happen and to be allowed. And so we have something which is called the Powers of Attorney Act. Now, we have this expression, which is called an enduring power of attorney. What people think is, oh, enduring. They think, well, just the plain old English meaning of that would mean, oh, it lasts for a long time. Well, enduring power of attorney has nothing to do with how long it lasts. What enduring power of attorney means is that it will continue to be in effect after one loses capacity. And this is the oddity about a power of attorney. If you don't say my power of attorney lasts beyond incapacity, it doesn't. So the minute you lose capacity, the power of attorney is of no effect. So you have to make it, make very sure that your power of attorney is enduring, i.e., it says it survives incapacity. Now, again, back in the old days, when we did powers of attorney, we had to state everything that the attorney could or could not do. And so guys like me spent all of our time trying to find fancy ways of saying everything. Well, everybody's power of attorney was a little bit different, and banks were always excited and worried and stuff. And so they amended the legislation to basically say, let's not put sort of everybody to the trouble of trying to figure out how to say everything. We're going to say the power of attorney allows somebody to do everything unless it's restricted. Sometimes a farmer might say, you can manage my affairs, but you can't sell farmland. So you can do that sort of thing. But if you make no restriction, understand the power of attorney can do anything that you could do. Now, the power of attorney does not have to come into effect immediately. You can make what we call a contingent power of attorney. And so what that basically means is that you can say there is going to be a condition that's going to come into play in order to make the power of attorney effective. The most common condition that people make is they say, I want my power of attorney to only come into effect if I lose capacity. And that's a pretty common thing that people do. And I would say probably 90% of the powers of attorney that I draft have that kind of contingency. Why do we want to do it? Well, I think people do it more so to just be careful and to say, look, I just don't want people to have the ability to wander around and sort of do whatever I could do unless I've lacked capacity. Now, the thing to understand, if you grant a power of attorney, it doesn't mean I mean, if you lack capacity, well, then you no longer can make decisions. It's only your power of attorney. But if you don't make your power of attorney contingent, in other words, you can make your power of attorney operative immediately. That doesn't mean you've lost the right to do things on your own. You can still do it. And it becomes pretty common for people to make powers of attorney operative immediately when they want to be in a position where somebody can sort of help them out and take care of things. And that often happens, for example, with elderly people that perhaps are somewhat infirmed, or they may lack mobility. Gee, I just had a hip operation and I can't get around, and it'd be nice to have, my son or daughter go out and pay my bills for me or do my banking or whatever. And, again, if the power of attorney was contingent on lacking capacity, well, they couldn't do it. But if you made it operative immediately, well, then they could do it. And so that becomes really, a choice of what's practical for the individual. And again, as I say, the power of attorney is very, very broad unless you restrict it. And again, a lot of the rules in terms of who, can do a power of attorney or who can't do a power of attorney, well, here we are. Again, it's really very similar to a will. You need to be 18 or more. You need to be mentally competent, and you need to sort of understand what you're doing. And so they're really all the same sorts of things. And, when you talk about, who can be given the power of attorney, again, has to be somebody who's 18. And again, it has to be somebody who has capacity and all that good stuff. Except what you have to do is also see here that it can't be somebody who's an undischarged bankrupt, and it can't be a person who has a conviction without consent. And it can't be somebody who's providing personal or healthcare to you. So you get yourself to a stage where you say, ultimately, one has to be a bit careful because, sometimes, we don't know if somebody's had a conviction or not, and we don't know whether they're an undischarged bankrupt or not. And sometimes those are difficult things to ask people. And I must say, most times people don't. But most times whether they have or haven't been. I think the idea behind being an undischarged bankrupt is, it's a bit of an old concept, but it's just basically saying, oh, well, perhaps that person, will not be able to sort of keep funds secure or, that sort of thing. But I think the key to sort of keep in mind is that really what we're looking at is it is somebody who ultimately needs to be at least 18 and needs to be somebody who understands. Now, we've talked about enduring and contingent. When I say you can give directions, we've talked about healthcare directions. And again, that is a separate piece of legislation. And healthcare directions come under something else that is called the Healthcare Directives Act. Now, that is a piece of legislation which is unique to Saskatchewan. Other provinces may have something similar, but it is unique to Saskatchewan. And again, what it allows you to do is to appoint a proxy that will make decisions for healthcare decisions for you. The one thing to keep in mind, and there may be another time when somebody speaks to you about MAID, but you cannot give the authority to a proxy to consent to assisted death. It's simply not allowed. A little bit different, who can make the directive? It's 16 or more. And so, again, it's a little bit younger than a will, but nevertheless, what's a bit odd is that, you can be 16, but whoever you are appointing, must be 18 or over, unless it's your spouse, who can be under the age of 18. Often I speak of in the context of appointing somebody, and this very last note here talks about you can have more than one proxy. The thing to keep in mind is that really you can have more than one executor or administrator. You can have more than one attorney. You can have more than one proxy. When you appoint multiple people to serve in these capacities, you can have them serve in one of three ways. You can make their decisions, you can force that their decisions be made unanimously. If it were three or more, you could say the decision must be made by a majority. Or you can allow decisions to be made what we call jointly and severally, meaning you get yourself to a stage where ultimately any one or all of them can make decisions or do things. Joint and several is becoming a pretty common thing that's being done, because often what will happen is that, for example, a parent who is not mobile may, have two or three children and say, hey, I want any one of them to be able to do it. It's whoever it's most convenient to do it. So I'll appoint all three and make it joint and several, meaning any one of them can do things. And so that sort of flexibility is there. People will often sit back and say, oh, does everybody have to live in Saskatchewan? Do they need to be near? Do they need to be, in the community that I live in? No. There was a time when that sure was an awful lot better, because we needed to get people to sign stuff, and it was an awful lot more convenient to have them around. In this day and age, there's more and more that we can do by email, by fax, by video conference like we're doing here. I now can witness documents over this medium. I can have documents sworn over this medium. The courts will accept documents that are faxed and scanned and that sort of thing. So distance isn't as much of a problem as it used to be. So don't sort of think you have to rule out some logical person just because they happen to be a bit of a distance away. That is certainly not something that needs to be done. Commonly, I must say that it is not uncommon that people will often appoint the same person to be their power of attorney as they do their executor. That's not uncommon. It's just a lot of times we get to a stage where people sit back and say, well, I don't have this long list of people that, either can or can't do things. Now, when I said with the power of attorney, you can create restrictions on the authority, it's the same with a healthcare directive. You can create restrictions with respect to what kind of healthcare decisions can be made. I'll give an example. If somebody is a Jehovah's Witness, they will say no blood transfusion. And so that's a restriction which can be made. I had somebody who came in and said, hey, one of the restrictions I want to make is no organ transplant. Okay, I mean, they're entitled to do that. For example, in my healthcare directive, I say I don't want my life to be artificially sustained by heroic measures. Now, that doesn't mean that somebody can assist my death, but it does mean that they're not entitled to artificially continue to keep me alive if I'm brain dead. So, you can make those kind of directions. And it can be very detailed, or it can be very simple, or it can be just wide open. Most times, I suggest to people, make a point of chatting with whomever you're appointing as your executor or your power of attorney or your proxy, so that they know your wishes. Because most times people do, what the person would like to have done. All too often, people don't have the conversation. And all too often, what is most distressing is that people, when they do these documents or when they make them, they somehow think they're going to die the next day. And, they contemplate their mortality. These are not documents meant just simply for old people or infirmed people. In fact, they're probably more important for young people, because young people have far more complicated things going on. They've got mortgages, they've got car payments, they've got bills, they've got credit cards, they've got all these things. A lot of retired people, I just got a pension and I've got whatever. Sometimes the older you are, the less complicated your life is. And so a lot of times, these documents are even more important for young folks. And so should not be thought of as a document, that is sort of only done sort of on impending doom, or on some kind of impending dangerous activity. They really aren't. They are a common sense set of documents that everybody should do, and they should do at as young an age as possible. So look, I think that's got me through as much as I'm going to get through without sort of, or at least to leave a bit of time for people to ask questions.
Well, thank you, Ted, for sharing your knowledge and personal experiences. I definitely learned a lot tonight about legal matters that I did not know that I did not know. Um, so I'm going to get you to stop sharing. I think
Yes,
I could
very
do
well.
that myself. Let's see. And
Yeah.
I,
If you know how to stop me sharing, that's good because
I, I,
have I done it?
I think I got it.
Okay, great.
Okay. And so now we'll soon be answering questions that has been typed in the question and answer box. If you haven't had a chance to type in questions, feel free to do that now. And just a little reminder that the questions have to be related to the topic tonight and that they cannot be a personal situations. While we're waiting for people to do that, I will talk a bit more about the Alzheimer's Society. Okay. Okay. So while you're entering your questions, I will share some slides on the Alzheimer's Society. The Alzheimer's Society of Saskatchewan is the province's leading dementia care and research charity. The vision of the Alzheimer's Society is to live in a world without Alzheimer's disease and other dementias. And the mission is to empower people to live well with dementia through the delivery of programs, services, advocacy, awareness, and research. We are accredited by Imagine Canada Standard Program for excellence in nonprofit accountability, transparency, and governance. The Standards Program is a Canada-wide set of shared standards for charities and nonprofit. Did you know that 3 out of every $4 that the Alzheimer's Society receives come from donations? Donations come in for events such as tonight's evening of education, as sponsorships, gifts left in wills, monthly donations, or as general donations to the society. A couple things to note is a person does not need a formal diagnosis to be connected with us. We support those affected by Alzheimer's disease and other dementias and have resources and knowledge about many different types of dementia. What clients can expect from the Alzheimer's Society of Saskatchewan. First off, individual information and support, available for both people living with dementia and their care partners. We have learning opportunities that include learning series, courses to help people with dementia and their families, and friends to live as well as possible with the disease. The courses build upon each other, covering the continuum of the disease. And of course, evening of education like tonight's event. Our standalone topics presented by content experts. We also have connections. We have support groups at the Alzheimer's Society. Support groups offer a chance to exchange information with others living with and affected by dementia. Access to the most current information. Learn and share practical tips for coping with change. Decrease feelings of loneliness and isolation. Express feelings and be reassured that these feelings are normal and find a sense of hope. We also have our Minds in Motion program, which is a 2-hour weekly program that combines physical activity and social activity for those in early stage dementia and a friend, family member, or care partner. Connection to other organizations. This includes providing information on available services provided by the health region, other government agencies, and a list of private or community-based organizations that help support people's dementia journey. Our shift to also offering virtual and online programming has increased our ability to provide additional programs to our communities. We have trained program and services staff that provide dementia information and support education throughout the province. Our provincial office is located in Regina, with additional resource centers in Saskatoon and various locations across rural Saskatchewan. In 2023-2024 fiscal year, we served over 3,000 clients from 336 different Saskatchewan communities. If you have questions about dementia or need to talk to somebody, call the province-wide toll-free dementia helpline phone number at 1-877-949-4141 or email helpline@alzheimers.sk.ca. It's available Monday to Friday, 8:30 a.m. to 4:30 p.m. Also, take a look at our Alzheimer's Society of Saskatchewan's website and connect with us through social media. On the website, you can scroll down to program and events to see our upcoming events information. Okay, so now we will start answering some of those questions. I'll stop sharing. Okay. So the first question, Ted, comes in. So what happens if a person writes a will in original handwriting and places a date on it but doesn't sign it, and then later on is deemed incompetent? Is that will still valid, or does it need to be signed?
Yeah, I can tell you that the general rule for a holograph will is that it ought to be signed. My experience has been, though, that there is a possibility that if one can prove to the benefit of the court that the handwriting is that of the testator, and it expresses, in a sense, what would be a complete picture of what they wish to have done. My experience has been that a court would likely allow it to be enforceable. It's a bit odd because, I mean, it really doesn't meet the formal requirements. And so one really does have a risk that it will not be accepted. But I do believe that there is a chance to have it done.
Okay, thank you. Okay, the next question has to do with power of attorney. So as enduring power of attorney, can the person make donations to charitable organizations? Example, Alzheimer's Society.
Actually, yes, that might sound a bit odd, but I mean, again, I spoke of the fiduciary duty, and that ultimately there is a responsibility to act in the best interest of the beneficiary, and in the power of attorney, that's the same thing. The person that you are we call the person who made the power of attorney the grantor and the power of attorney. So the power of attorney does have a fiduciary duty to the grantor. But provided that it would be affordable, there generally are allowed to be donations, but they are restricted in value. And offhand, I think it's $1,000. I think it can't exceed that amount, but there is a specific number that is set out, and it's not a huge number, but it's restricted in amount, and it is also restricted in the context of affordability. So if the person really sort of needed those funds, month to month, it would not be something that would be allowed, that would, in a sense, put the person in a deficit position.
Okay, thank you. Okay, the next question is, who determines whether somebody is competent? How is this determined?
Yeah, good question. Within a power of attorney, you can state how it is determined. So, Heather, you could say, gee, my capacity can be determined by Ted Koskie. Now, you wouldn't want to do that, but you could do that. Normally speaking, people don't specify. And when it isn't specified, the legislation says it must be two healthcare professionals that certify. Those healthcare professionals are not necessarily doctors, but it could be, for example, a psych nurse and a doctor, or I think even a certified social worker. But they must be two professional healthcare workers that certified.
Okay, thank you. The next question says, should a healthcare directive be done by a lawyer, or will one downloaded by the health region or filled out by a doctor good to use?
Yeah, you're catching my pet peeve. It's becoming very common in this day and age for people when they go into a hospital, particularly for an operation, to have the administration sort of plunk this healthcare directive in front of them, which generally is a multiple page document with a whole bunch of boxes to tick off saying you can either do this or can't do that. And I become very annoyed when those things are given to people, because firstly, they're being given to them at a stressful time. And they're also being given at a time where a person really doesn't have the opportunity to sit back and think about it. Most times when we are appointing a healthcare proxy, we're appointing somebody who we trust to make decisions. And again, when I say trust, generally we're trying to appoint somebody who we think will make decisions like we would make them. Now, of course, it's not going to be perfect, but we try to pick somebody that's going to do it as closely aligned as we think they would. And so, one, I don't think a doctor should be doing it. I mean, it's none of the doctor's business whether you want a blood transfusion or don't want a blood transfusion. It's not the hospital's business either. My view is when hospitals plunk these things down in front of you, they're doing it because they're afraid of getting sued. They want to say, okay, you ticked off this box, and because we did it, now you can't raise Cain with us for having done it or not having done it. They should be relying on the proxy. If the person doesn't have the capacity to make that decision, they should be allowing the proxy to make that decision. So my view is one is far better off using the services of a lawyer to draft these things so that there's the opportunity to have the conversation, to discuss what that person wants, and to make sure that the appropriate person is appointed to make the decisions. And this stuff of giving people, a lengthy document sort of at a time they're about to go in for an operation, to me, is just, in my view, bad practice.
Thank you. I have another question that relates to power of attorney. So the question is, as enduring power of attorney, can I pay myself for time and gas for attending appointments?
Yes. A power of attorney is entitled to a reasonable fee. And in practical terms, fee is often a bit of a dicey thing, both with wills and with powers of attorney. But yes, a power of attorney is entitled to a fee, is entitled to a reasonable fee. I say they've got to be very careful with it because, again, they have a fiduciary duty. Covering expenses is never something that's been problematic. And paying somebody a stipend to do it, I guess generally is something that has been acceptable. But they run the risk that either the public trustee or another member of that person's family may challenge that. And my view is, I can honestly say, in all the time I've practiced, it's been pretty rare that I've seen powers of attorney that have actually charged a fee. But yes, my view is they are entitled to a reasonable fee. And I would say that would be a pretty small number. And it depends what the person's doing. If the power of attorney is sitting back saying, holy smokes, this person, had all sorts of investments, and I'm spending huge amounts of time sort of, cashing in bonds or, giving instructions to a stockbroker to deal with things, then yes. And courts generally would sort of approve something, and usually it's based on a percentage of what you're dealing with. And so usually that's a small percentage, but it might be 1 or 2% of the value of what you're dealing with. But again, it has to be something that has been pretty active. It's not like you just have a dormant bank account that you say, oh, great, this person has $1 million in the bank, I'm going to get 2% of it, sort of whatever. That generally isn't there. It has to have some realistic tie to what you're doing. As I say, my experience generally has been people look only at expenses, but yes, they are entitled to a reasonable fee. There's a way around it. A person can, not only within the will, but also within the power of attorney, state what compensation the person gets. And then the courts are very strict. They say if you set it out and the person agrees to be, they're stuck with it. And so that's one way to protect yourself, is just simply say, if my power of attorney accepts, this is what they get paid. Bang. There's never a worry about it.
Good. Now, this one is a question that came in is, what happens if your spouse is determined to be without capacity, but does not have a power of attorney or health directives already set up?
No, I'm sorry. If you could, I missed the first part of.
What happens if your spouse is determined to be without capacity, but does not have power of attorney or health directive?
Yes. All right. Now, when one has a family member that lacks capacity but does not have a power of attorney, the only way we can be at a point of being able to make decisions for that individual is to actually make an application to the court to be appointed as a guardian. And there is a piece of legislation that deals with guardianship. It sets out sort of a set of rules. But when there is a lack of capacity, one can apply and say, look, court, appoint me to be the guardian. And in a sense, it will set out almost the same sort of duties and rights that you would see in a power of attorney. Courts can be restrictive. And when guardians are appointed, there are sort of different reporting requirements that you need to make with the court, but nevertheless, that's what you're stuck with, is making the application to the court. And it's a bit of a pain in the butt, because when you make that application, you have to file medical evidence of the person's incapacity. You have to serve everybody that might have an interest. In other words, everybody in the family that might, like if it's brothers and sisters or whatever, you have to serve them all. You have to set out for the benefit of the court what the estate is, in other words, what the person has, what their expenses and debts are. So it's a bit of a drawn out process. It's not as though it's hard to do, but it's tedious to do, and it's often a bit expensive to do. So it's often the reason why I say to people, doggone it, do the power of attorney while you have capacity, because if somebody has to make that application for guardianship, then you have a bit more of an expensive process. But that's the only alternative. There was a day long ago, when, I don't know, the local bank would say, okay, I know their spouses and I'll let one spouse do it. That day has gone a long time ago. Just doesn't happen. I found people that won't even agree to let a spouse place another person in a special care home without having either a power of attorney or a guardianship order.
Well, thank you. So our time is up for the evening. Again, I would like to thank you, Ted, for speaking tonight, and to our sponsors, SGI and SaskTel Telcare. And thank you to the team of Alzheimer's Society who worked hard tonight behind the scenes to make this presentation run smoothly. The presentation tonight was recorded, and following tonight, an email will be sent out to you the next day or two with a short participant survey and education resources links. The link to the recorded presentation will be available on the Alzheimer's Society YouTube channel within the next few weeks. Thank you again for joining us, and have a wonderful evening, everyone.